Chief Justice, colleagues, friends of the Selden Society, welcome to this lecture in the Banco Court, which happens on land that by tradition is in the custody of the Turrbal and Yagara peoples. This is our first Selden Society lecture for 2023, and we are very pleased to have with us to deliver the lecture Mr. John McKenna KC. John has been a member of the Queensland Bar for more than 30 years, including more than 20 years as a silk. He has a particular interest in appellate and legally complex matters. John graduated from the University of Queensland with a Bachelor of Arts, majoring in economics, and a Bachelor of Laws with first-class honours. He was awarded a Rhodes Scholarship for Queensland. He studied at Magdalen College, Oxford, graduating with a Bachelor of Civil Laws with first-class honours, and undertook several years of postgraduate research into the history and modern expression of the doctrines of estoppel before returning to practice here. He is a Fellow of the Australian Academy of Law, an Adjunct Professor of Law at the University of Queensland, the President of the University of Queensland Law Alumni Association, and Chairman of the Incorporated Council of Law Reporting for the state. John is also a member of the Supreme Court Library Committee, a member of the Statutory Legal Practice Committee, and the National Secretary of the Association of Rhodes Scholars in Australia. And perhaps most self-referentially, I would say, John is the author of A History of the Supreme Court of Queensland, a concise history published in 2021. Tonight, the topic is Mr. Justice Harding, a titan of Queensland law, and to present the lecture, would you please make welcome John McKenna KC.
Your Honours, ladies and gentlemen, within this very modern courthouse, a place that means a great deal to me is the portrait gallery, which stands outside this courtroom. It's not really the artistic quality of the portraits which is the attraction. The attraction is the way the gallery quietly honours and pays respect to the collective lives and work of 7 successive generations of the judiciary in Queensland. The tradition of paying respect in this way to the titans of our court can be traced back to events in 1895. These were the events surrounding the death of a judge of the Supreme Court, Mr. Justice George Rogers Harding, who died in his chambers on the morning of Saturday, 31 August 1895, at the age of 56. Harding was a man renowned for his public-spirited nature and devotion to duty. 4 days earlier, on the Wednesday, he had fallen seriously ill during the course of his summing up in the civil jury trial of Kinnavan and Cleland, and had to adjourn the hearing and retire to his chambers. Doctors came to his assistance, including Dr. Ernest Sanford Jackson, the great-grandfather of former Justice David Jackson of this court, but Harding was too ill to be moved home. The next morning, characteristically, Harding invited counsel and the jury to his chambers and completed his summing up, despite suffering acute chest and abdominal pain. The jury returned with its verdict later that afternoon, but by then, Harding was too ill to receive it, and Mr. Justice Reel, with the consent of the parties, stepped in to conclude the trial. As the newspapers of the time described it, a hush lay on the city as the judge's condition worsened and he lay gravely ill in a bed which had been moved into his chambers. After enduring 3 days of acute pain, Harding died in his chambers early on the Saturday morning with his family around him. In central Brisbane, flags were lowered to half-mast and shops put up their shutters. During the day, and until almost midnight on Saturday, hundreds of people were allowed into Harding's chambers, where his body lay in state, to pay their final respects. A special government gazette was quickly published, advising of the funeral arrangements for the following day, Sunday, and on that Sunday, crowds lined North Quay for about a kilometre to watch a funeral cortege of about 50 carriages move from the courthouse in George Street to Toowong Cemetery. On the following Monday, most matters in the Supreme Court were adjourned, and on the Tuesday, the full court held a valedictory sitting in Harding's honour. Then, a few days later, a meeting of the legal profession was held in the offices of Crown Law, and a committee of 19 members was appointed to consider how best to create a memorial in Harding's honour. It was from this meeting that the idea developed of raising funds to commission a portrait of the judge, which could be displayed in the central hall of the Brisbane courthouse. The artist who was commissioned was Mr. Richard Godfrey Rivers. In modern Queensland, Godfrey Rivers is most widely known for his picture Under the Jacaranda, which is one of the most beloved pictures in the Queensland Art Gallery. In 1895, Godfrey Rivers was a leading figure in artistic circles in Brisbane, having been appointed the inaugural curator of Brisbane's first public art gallery, the Queensland National Art Gallery, which had opened in the Town Hall earlier that year. Harding's portrait became the first to be displayed in the Brisbane courthouse and led to a practice of further portraits being commissioned by the legal profession from the same artist upon the death of the most inspiring legal figures of the era. Chief Justice Sir Charles Lilly, T.J. Burns, a brilliant lawyer who became Solicitor General, Attorney General and Premier before dying at the tragically young age of 37. And may I say, I think that's actually the best portrait of the lot. It's, to me, a very moving portrait of a young man. And the Chief Justice Sir Samuel Griffith. These portraits were all on display in the central hall of the old courthouse, and fortunately, all of them survived the courthouse fire of 1968, inspiring thereafter a renewed interest in commissioning further portraits to add to the collection. This outpouring of respect for Harding raises a few questions which merit further consideration. Just who was Harding? Was it simply his last heroic act of remaining at his post until death which attracted the admiration of the Victorian era? Or was the respect for him more profoundly based? And if it was, how should we now, in retrospect, assess his contribution to the justice system in Queensland? Well, Harding was very much a product of the Victorian era in England. He was born on 3 December 1838, only about 18 months into Queen Victoria's reign. His place of birth was in the village of Ash Priors, near Taunton, in the idyllic English county of Somerset. His father was an Anglican minister, the Reverend George Rogers Harding, who was very well educated. Harding's father had commenced his studies at Queen's College, Oxford, where, coincidentally, he was a contemporary of Alfred Lutwich, who was later to become the first judge of the Supreme Court. Then, after the Reverend Harding's ordination as a deacon, he completed a Bachelor of Civil Laws degree, which was then a degree in Roman law, at Queen's College, Cambridge, and later married. The Harding family were by no means poor, but they were also not particularly well off or well connected. For Anglican ministers who had the financial means or connection, their career path at the time ordinarily involved securing a permanent appointment as a rector or curate to a parish which came with valuable rights to a source of income. For Reverend Harding, however, he initially seems to have accepted a series of shorter-term appointments in various villages in Somerset before a permanent position became available in the village of Gittisham near Honiton in Devon in 1854. By that time, the young George Harding was about 15 years of age. And as Justice Harding later recalled, this was a turning point in his life. It was a turning point because he had the opportunity to meet two retired judges who lived in the area, Mr. Justice Coleridge and Mr. Justice Patterson. And these meetings led him to consider a career in the law. Coincidentally, it was during this period that he also met the Pring family who lived in the area and whose son Ratcliffe Pring was a young barrister who had emigrated to Australia. Ratcliffe Pring was later to become a colleague of Harding's, both at the Queensland Bar and in the Supreme Court. By this time, Harding had also developed his great love for books. In later life, Harding reflected that he'd always had a great weakness for books and recalled that, even at the age of 15, living in the heart of rural England, his personal library included a range of quite unusual books, including Williams's Dictionary of the New Zealand Language, which contained a collection of Maori words and their English translation. Harding attributed to this book in particular an early fascination with Australia and New Zealand. In 1856, the young Harding commenced as an undergraduate at Magdalen College, Cambridge, but he left Cambridge to study for the bar before completing his degree. In the summer of 1858, he commenced reading for the bar at Lincoln's Inn and was eventually called to the bar in April 1861. Four things from this era are of importance. First, Harding was drawn immediately to a practice in Chancery and received excellent training under the tutelage of leading practitioners of the day. This is significant because it was this specialty which, unusually in Queensland, Harding pursued. Secondly, he became an avid user of what was perhaps the most impressive law library in England at the time, the New Library at Lincoln's Inn. Queen Victoria had opened the new Great Hall and Library complex only a few years earlier, in 1845, but even in Harding's time, it had 80,000 volumes, including an extensive collection of early legal manuscripts and rare books. While the Lincoln's Inn Library has since been extended and modernised, and that's a modern photograph of it, the essential look and feel of the library is largely unchanged. And if you're in London, I would recommend that you visit it. In Harding's later life, it's not difficult to see the influence of this library in both his personal book collecting and his leadership of the Supreme Court Library. Thirdly, he published his first legal text, a handy book of ecclesiastical law, a bestseller if ever I heard one. This is significant because, as we will see, one of Harding's significant contributions to Queensland law was in writing some of our first local legal texts. Fourthly, despite his youth, he played a leading role in the community of Lincoln's Inn. Harding established a debating society at the inn, which quickly grew to some 200 members. This was an early indication of Harding's gregarious and engaging nature, which carried over to both his professional and personal life in Queensland. After his call to the bar in 1861, he married, and before long met with considerable professional success. We know quite a lot about this period in Harding's life because he described it in detail in a series of interviews he gave to the Brisbane Courier in the year of his death. It seems that, in his early days in England, he was maintaining chambers with clerks in both London and Birmingham, that he appeared with some of the leading Queen's Counsel of the day, and that his income was around £1,500 per annum. And to put that in perspective, this was the same level of income which was being offered to Sir James Cockle to become Chief Justice of Queensland. On 12 July 1866, however, Harding decided to emigrate to Queensland. And the obvious question is why? For most emigrants, there are both push and pull factors that contribute to their decision to move to a new country. In Harding's case, there were certainly some good reasons to move to Brisbane. Harding's wife had a sister who was married to a prominent Brisbane solicitor called Eels Brown. This couple had moved to Brisbane in 1860, about 6 years earlier, and quickly became leading citizens of the new colony. Eels Brown had gone into partnership with Robert Little, the Crown Solicitor of Queensland, who also had a thriving private practice, and they formed the leading Brisbane firm of Little and Brown. Over time, Little and Brown evolved into the Brisbane firm of Fates Ruthning, which in turn evolved into the modern firm of Allens. Brown was also an appointed member of Queensland's Upper House, the Legislative Council, and became one of Brisbane's more notable and prosperous citizens. So professionally and personally, there were some good reasons for Harding to consider a move to Queensland. But 1866 was hardly the year to do so. Queensland still had a fledgling economy, founded largely upon the agricultural sector, but the colony was then in a state of financial crisis, with widespread unemployment and civil unrest. As to the Queensland Bar, well, it was really a place for rough and ready all-rounders, for practitioners who were just as comfortable defending cattle duffers as in resolving property disputes. So Queensland wasn't an obvious choice of jurisdiction for a barrister with an interest in the mysteries of ecclesiastical and chancery law. But recent research has uncovered what appears to have been a significant push factor influencing Harding's decision. On the 22nd of June 1865, a select committee of the House of Commons published a report examining some dubious dealings involving Harding's father, the Reverend Harding, who was then Vicar of Wandsworth in London, Mr. Richard Bethel, the impecunious son of the Lord Chancellor, Lord Westbury, and a Mr. Welch, a wealthy barrister who was hoping for a court appointment. I think you can see where all this is leading. May I read to you an excerpt from this report, which describes the remarkable evidence given to the Select Committee by Harding's father. The committee reported that Mr. Bethel had for some years been acquainted with Mr. Welch, and in April 1865 had some negotiation with him as to raising a sum of £6,000, an enormous sum. While this was pending, Mr. Bethel was in immediate need of £500. So an arrangement had been made that Mr. Bethel should use his influence to procure an appointment from his father, the Lord Chancellor, in favour of Mr. Welch. And for doing so, Mr. Welch should pay £500 down, and on obtaining appointment should pay £1,000 more. The understanding was clear that £500 was to be paid to Mr. Bethel on the security of a bill of exchange at short date, which was to be destroyed or returned if Mr. Welch obtained an appointment. And the understanding was also that the Reverend Harding was to receive 1/3 of the further £1,000 when it was ultimately paid. In fact, pursuant to this arrangement, the money was paid by Welch to Bethel, the appointment of Welch to the Leeds Bankruptcy Court was secured, and then Bethel decamped with all the money. The Reverend Harding, who seems a somewhat innocent soul, politely wrote to Welch asking for his 1/3 share, but to his apparent surprise, his £333 was not forthcoming. This sensational evidence was widely publicised in the English press. The Lord Chancellor, Lord Westbury, was obliged to resign, and by 13 February 1866 it had been announced that a decision had been made to prosecute his son and Mr. Welch, with the Reverend Harding to be the key witness for the prosecution. On 1 July 1866, however, just before the trial was to commence, it was reported to the Court of Queen's Bench that the Reverend gentleman had left the vicarage with his family and servants, bag and baggages, and was not to be found, so that a subpoena couldn't be served. As a consequence, the prosecution doesn't seem to have proceeded. It wouldn't seem to be a coincidence then that 12 days later, George Harding and his family were on a ship to Queensland. The voyage to Australia was a fast one for the time, 78 days, and shortly after arriving on 31 October 1866, Harding was admitted to the Queensland Bar, with his admission being moved by Radcliffe Pring. At that time, as you probably know, the heart of the legal precinct in Brisbane was at this end of Queen Street. The Supreme Court and the Parliament were based in the old convict barracks, shown in the far right of this image, which, may I say, is quite a rare photograph of that building. Most barristers had their chambers in the offices in the lower floors of the newly opened Town Hall, which is shown in the middle of this image. At the time, there were only 2 Supreme Court judges, Chief Justice Cockle and Mr. Justice Lutwich. A system of district courts had just been established, providing 3 additional judges for the colony. However, there were only about 15 practising barristers, including 2 QCs, Pring and Lilly. There were only about 40 practising solicitors, most of whom were based in Brisbane or Ipswich. Harding was rather different from his colleagues in 2 main respects. First, he became the colony's first specialised counsel, focusing entirely on what we would now call commercial, property, insolvency or estate matters. Whilst this may have been challenging in the recession of 1866, it proved to be a brilliant specialty to have in the years to follow, when the discovery of gold at Gympie led to the growth and diversification of business activities, particularly corporate activity in Queensland. In Bruce Macpherson's history of the Supreme Court, it suggested that Harding didn't have much of a reputation as an advocate, but was highly respected for his extensive legal learning and immense capacity for hard work. As to Harding's reputation as an advocate, the evidence suggests that he was a little condescending and prickly in his courtroom manner, but there's no doubt that he had an incredibly busy practice, appearing in most commercial cases of any substance. As to his legal learning, the Supreme Court Library has surviving examples of Harding's written advices from this period, which were to the firm of Little and Brown, and were preserved in the Fates-Ruthning opinion books. These opinion books contain a wonderful record of over a century of written opinions given by Queensland's leading counsel, including Samuel Griffith and George Harding, to the various law firms which combined to become Fates Ruthning. Like all the opinions from this era, Harding's work was expressed succinctly in a few hundred words, with references only to the key authorities, but they suggest a methodical and scholarly approach to the issues he was briefed to consider. The second feature which distinguished Harding from many of his other colleagues, such as Lilly and Griffith, was that he focused his efforts on legal practice rather than seeking to pursue a parallel career in Parliament. This choice seems to have been a wise one, because the main flaw in Harding's character was his impulsiveness. To Harding's credit, he does seem to have had some insight into this shortcoming and would often follow up intemperate remarks with profuse apologies. However, this character flaw was exposed rather starkly in his first and only venture onto the hustings in the 1870 elections. In those elections, he was encouraged by his colleagues to stand for election against the sitting members for Brisbane, including Dr. Kevin O'Doherty, who is known to many of us as the doctor who delivered the infant who was to become Lord Atkin. On 5 August 1870, at a public meeting at Victoria Hall, Harding took to the platform and explained rather eloquently where he stood as a political independent on a range of issues, generally to the cheers and applause of the crowd. Things then took an unfortunate turn. When he began to criticise the sitting members, there was an interjection from the crowd. "What about O'Doherty?" To which Harding responded to the effect, "I am not afraid of him. I will tell you what O'Doherty liked. He liked a woman brought to bed. That was what the accoucheur liked." Now, this insult requires some explanation. In the Victorian era, there was some controversy about whether childbirth was more appropriately managed by female midwives or by male doctors who claimed to have greater expertise, but whose involvement was not considered by some to be entirely appropriate. The word accoucheur here was used as a slighting reference to a male doctor of this kind, particularly one who seemed just a little too enthusiastic about this aspect of their practice. Harding's remark understandably caused an indescribable uproar at the meeting, with a wall of hisses and groans, and with most of the audience, including Dr. O'Doherty, walking out. Harding immediately and repeatedly apologised, but that was both the beginning and the end of Harding's venture into politics. Harding was only in practice at the bar in Queensland for 13 years. He didn't take silk, but you can see from the court reports of the time that he was very much in demand, and was earning as a junior about £4,000 per annum, almost double the judicial salaries of the time. This very substantial income stream funded Harding's personal interests. Harding was a gregarious man who in some ways wished to emulate in Queensland the lifestyle of the English country gentleman. So in 1868, he took a lease of a very large estate called St John's Wood, situated on Waterworks Road. Harding eventually purchased this property in 1874 and continued to expand his land holdings thereafter. The house was home to his very large family of 15 children in all, 3 of whom died in infancy. It was also home to his very large personal library of some 5,000 volumes, with a further law library held in his chambers of about 2,000 volumes. With its ballroom and extensive grounds, St John's Wood was effectively operated as an open house, which was welcoming to a wide circle of legal and other friends. Just as Harding had himself been the beneficiary of the kindness and encouragement of more established colleagues in England, he was noted for the generosity of his friendship and support for colleagues in Brisbane. The year 1879 was a significant one in the legal history of Queensland. It was the year in which the Supreme and District Courts moved into a new courthouse in George Street. This building only had 3 courtrooms, but now had a central law library. It was also the year for a judicial changing of the guard. Sir James Cockle, Queensland's first Chief Justice, who was on leave in England, gave notice that he wasn't proposing to return to Queensland. So in his place, Mr Justice Lilly was appointed Chief Justice, and in July 1879, Harding, at age 40, was appointed to replenish the numbers on the court. Harding became only the 5th judge of the court, joining a bench of 4 comprising 3 Brisbane-based judges, Lilly, Lutwich and Harding, and a northern judge in the town of Bowen, Mr Justice Shepherd. Harding's appointment was universally welcomed as a non-political appointment made entirely on merit. Harding then commenced a term of over 15 years of judicial service, becoming one of the most respected judges of a very strong court, which eventually included Justices Cooper, Chubb, Reel and Griffith. An example of Harding's judicial skills can be found in what was one of the most significant cases of the era, in which the mining titles of the Mount Morgan gold mine were under challenge. In that case, Harding had the courage to deliver the judgment of the full court ex tempore in 1886, and that judgment was upheld by the Privy Council in 1888. More controversial was Harding's role as trial judge, sitting in Rockhampton in April and May 1891. During this sitting of the court, a number of criminal trials were heard arising from the shearers' strike of that year, involving charges of sedition, riot and conspiracy. In the end, 19 of the strikers were convicted, with quite a few receiving the maximum sentences of 3 years imprisonment. Harding's role in this trial placed him at the centre of political controversy, with very personal criticism of him by the Labor movement continuing over time, particularly because of the severity of the sentences which were imposed. In retrospect, however, this criticism seems to have been prompted more by Harding's prickly and somewhat theatrical manner, rather than by any error in the conduct of the trial. On the centenary of these trials, in 1991, former Justice Demick of the Supreme Court reviewed the conduct and outcome of the main conspiracy trial and came to the view that both the verdict and the sentences were properly reached. He also concluded that Mr Justice Harding's forthright expressions of his opinions to the jury were not out of keeping with judicial attitudes of the 19th century. But can I give you some examples of the kind of exchanges which occurred? On Monday, 18th May 1891, the jury retired to consider their verdict in the matter and were sequestered overnight. The next morning, Harding summoned them back to court to inquire about their progress, and the following exchange then occurred with the foreman. Foreman: "Some of the jury have had nothing to eat since yesterday morning." Harding: "Nothing to eat? That's bad. What do you want?" Foreman: "Something to eat." Harding: "Well, gentlemen, it is a reasonable request, but you didn't ask for it last night, and the court never acts unless it's moved. When the court is sitting, it's always ready to hear any applications which may be made, but this is the criminal side of the court, and if it once adjourns, nothing can be done until it reopens. As it happens, I took the trouble last night to look up the powers I am possessed of, and I find that I can, in court, order fire, light or reasonable refreshment to a jury, so you can now order a reasonable breakfast." From this exchange, you get a sense of Harding's judicial method, a method of strict adherence to principle that was apt to cause surges of adrenaline for anyone else in the courtroom. A second example from the trial arose a day later, when the jury, with the benefit of something to eat, were finally able to agree upon a verdict of guilty, but perhaps by way of compromise, requested that the court be as lenient as possible with the prisoners. When the foreman was unable to explain the reasons for this request, Harding responded in these terms: "Then your recommendation is only a sort of Christian feeling. Very good. Well, gentlemen, I'm always very glad to have advice from a jury, but unless they have considered it, I find it better that they should stick to their business and I will stick to mine. You have given me a little advice and have given me no reason. I am a Christian as well as yourselves, and I will bear in mind what you have said." He then proceeded to impose the maximum sentence of imprisonment available. This is an example again of Harding strictly applying the law with little patience for those who had a less rigorous approach. In fact, when you read through the newspaper reports of Harding's cases, they are replete with further examples of Harding's demanding approach. Harding objected to practitioners who sought to appear in court in tweed jackets rather than in dark suits. Harding fined jurors for contempt if they were late for court. And on one occasion, when a man in court approached opposing counsel, who happened to be Samuel Griffith, with what he described as a six-shooter in good order and ready to go off, Harding threatened to sentence him to 40 years imprisonment for contempt. However, one of the more memorable stories about Harding dates from 10 November 1887, when an intolerable smell of sewage filled the Brisbane courthouse as a result of a defective drain. The court had repeatedly asked the government to make the necessary repairs, but you may be surprised to hear, nothing was being done. So Harding took matters into his own hands. When the court opened, Harding told the civil jurors who had assembled of his concern that all of their health was at risk, and decided to conduct an impromptu judicial investigation into the propriety of any proceedings continuing to be heard in the courthouse. Harding brought his own doctor to court and directed him to enter the witness box. Having sworn in the witness, he then received the doctor's expert opinion on the situation at some length, including his conclusion that anyone frequenting the court or its precincts was liable at any time to contract serious and dangerous disease from the tainted atmosphere. Harding then invited anyone who wished to cross-examine the doctor to do so, and allowed the members of the jury panel themselves to give sworn evidence about the effects they had experienced from the foul air. The jury panel was then invited to retire and consider whether they wished to proceed, and perhaps not surprisingly, they came back with a decision not to proceed with any new cases until the government fixed the drains. During these last 15 years of his life, Harding's contribution to the law in Queensland wasn't confined to his work in the courtroom. Sensing the problems created by the absence of local legal texts, Harding returned to legal writing. Over the course of about 10 years, he wrote 6 texts concerning the law of Queensland, which were then made available, free of charge, to the profession. The most notable of these works was an annotation of the statutes relating to civil procedure, which Harding had published in 1885. Then there were similar annotated works on insolvency in 1887, criminal procedure in 1887, the Settled Land Act in 1889, and joint stock companies in 1895. During the same period of almost 10 years, Harding served as the chair of the Supreme Court Library Committee. At the time he took up the role, in 1887, the collection was a perfectly respectable set of about 1,000 volumes of mostly English nominate law reports and textbooks, a collection about half the size of Harding's own law library. By the time of his death, however, the library's collection stood at about 10,000 volumes, and the change wasn't merely numerical, it was a change in collection philosophy. The library was no longer content merely to provide practical books for the day-to-day work of the court. Rather, it sought to reproduce in Brisbane the kind of reference library which Harding enjoyed as a young man at Lincoln's Inn. This involved expanding the collection in 3 complementary directions. First, in relation to the contemporary law, Harding began to assemble a comprehensive set of current English texts and law reports. Secondly, to allow research into the origins of legal principles, Harding acquired for the library the most influential volumes in our legal history, many of which were very old and very rare. Thirdly, to remain sensitive to developments in the law occurring in Canada and the United States, Harding began to collect a very extensive set of North American materials. In short, it was largely Harding who established the Supreme Court Library as one of Australia's great legal research libraries. After the initial shock of Harding's death in 1895, more shocks were to come for his family. First, they discovered that Queensland's leading equity and estates lawyer had died without leaving a will. Secondly, they discovered that there was probably no real need for a will because his estate was insolvent. Harding was asset rich with extensive land holdings and personal property, including his personal library, but he also had a staggering debt to the Queensland National Bank of about £22,000. Economically, this was a terrible time to be in this position, as Australia was in the grip of its most severe financial crisis, with a collapse in property prices and banks failing. The consequences for the Harding family had been carefully traced by Brisbane lawyer Paul Sayre in his published study of Harding's life. It involved the family's eviction from St John's Wood and the entire landholding being taken by the bank to cover the estate's debts. The only positive news from this period concerns the fate of Harding's personal library. After the opening of Brisbane's first public art gallery earlier in 1895, attention had then turned to the establishment of a public reference library, and Harding's death seems to have given this movement further impetus. It created an opportunity for the colony to acquire a fine selection of about 3,600 key reference works to form the foundation collection for the new library, and by January 1896, this opportunity had been taken up. It seems that the Harding family, in their time of need, were only paid about £500 for this collection, but it was this collection upon which the Brisbane Public Library was founded, and in this way became the foundation collection for the State Library of Queensland. So to return to the questions I first posed about the significance of Harding to the law and history of Queensland, I suppose his most tangible contribution was to its intellectual fabric, through both the Supreme Court Library and to what is now the State Library of Queensland. But I expect that the real contribution made by Harding, which led to the outpouring of respect upon his death, was of a less tangible nature. Harding, Lilly and Griffith were all extraordinary figures in colonial Queensland. They brought to our profession and to our legal system a precision of thought and a depth of analysis which set the standards for generations to follow. They were the titans of our court.
John, thank you for sharing with us those snippets from a really significant life. And thank you for the breadth of the research that you've undertaken to take us right back to the beginning and then through really in great detail the whole of his public life here. So that next time any of us sees the portrait of Harding that's hanging outside, we'll know a lot more about the person behind that image. Who would have thought, for instance, that he would have had a similarly lengthy political life to Mal Meninga? But it's fair to say that he's had a more enduring influence on the law here, on the practice of the law here, and he and the other titans that you mentioned really set a standard for practice here, which has been really significant for the development of the law here and the development of the whole of the community. So thank you very much on behalf of all of us here. Would you accept this very tiny token of our appreciation? And it only leaves me to invite you to join with me in thanking John for his presentation. You now have the opportunity to see the portraits outside in the gallery and join us for a drink and some refreshments there. So you're most welcome to do so. Thank you very much for attending. Thanks, Ross. Thank you.